Well, hello once again. Welcome, Disability Law Show. John Scholes, Sivan Tumarkin, reaching out right away. Here's how you do it. 1-855-821-5900. DisabilityRights.ca is the website, or help@disabilityrights.ca to send along an email. We'll get to a bunch of those today. A lot of stuff to cover on the show. We're going to get to some emails and phone calls. Sivan, going to be a busy day. As well, we're going to get to 3 reasons you should call a disability lawyer before you go to that independent assessment. That's coming up. But first, tell me a story, a week that was. What's going on in your end, pal?
John, again, it's been very, very busy. And let me tell you something that I have not seen before. It's something that happened for the very first time, which I find interesting and concerning at the same time. So we're going to talk later on the show about independent medical assessments. And, you know, the word independent is in quotes because, again, remember, the insurance companies are arranging for these assessments and they're paying the individuals who are assessing you. So I get an email from a gentleman in BC, and that person emails me and says, the insurance company, my insurance company, has arranged for me to see an assessor, but here's the thing, they want me, and by they he means the insurance company, they want me to sign a waiver that waives my rights in case I contract COVID as against the insurance company. So I'll say that again, they want him to sign a waiver. They're asking him to go to this assessment in person, and they're asking him to sign this waiver to waive away any liability on behalf of the insurance company if he contracts COVID.
Wow.
Now, remember, the insurance company, and we're not just talking about disability here, it can be any insurance contract. It is exactly that, it's a contract. So in the disability context, long-term disability, you're only obligated to do what the insurance policy, what the disability policy requires you to do, just like the insurance company is only required to pay you what the disability policy says that they have to pay you. Nowhere in these policies does it say, I assure you, nowhere does it say that you have to sign a waiver that waives your rights with respect to COVID if you attend an independent medical assessment. And so my advice to this gentleman was, you do not have to sign this waiver, and in fact, you should not be signing this waiver. And if the insurance company wants to organize a virtual assessment, or they do want to take liability on themselves in case you contract COVID, which hopefully you will not, then that's fine, but you should absolutely not sign away your rights just because the insurance company is asking you or instructing you to do that. And the takeaway from this, John, is that you have to make sure that you question whatever your insurance company is telling you, especially when you're dealing with long-term disability. And I see this time and time again with people who are watching the show or listening to our radio show or reading what we write on our website and in the media, where they get informed and they contact me and they say, I didn't know that. I simply assumed that my adjuster was telling me exactly what the policy says, or that the insurance company is correct in denying me the claim. And when I look at their cases and when I talk to them about their specific situations, I tell them, no, the insurance company is wrong. So the takeaway is question your insurance company. Okay? Do not take anything at face value. If your adjuster is telling you that they're going to deny your claim or cut you off payments, or that you have to do this or have to do that, ask them where in the policy does it allow them to do that. Okay? Put their feet to the fire. And then feel free to contact me, anyone on my team. We're going to give you this information. We're going to talk to you for free to make sure that you're informed and that you have the information you need to arm yourself when you're dealing with your insurance company.
Seems kind of a slippery slope. This time it's COVID. Next time it's the flu. After that, it'll be some other disease you're not allowed to get if you walk out of an assessment. I don't know. I wouldn't sign it either.
100%. 100%. But people don't know that, John, and that's a good thing that this person had emailed me. And I'll tell you this, that was just one person. How many individuals across the country are probably facing that same waiver, and how many of them have actually probably signed their rights away? So, you got to be careful. You got to tune into the show, and you got to inform yourself. You got to empower yourself by getting this information.
Tune into this show and, of course, the long-running radio show as well, disabilityrights.ca. That's where you'll find a link to the radio show. Get a lot of phone calls on the show, as you know, Sivan. We answer them all week, and we play some of them back here, and we talk about them. Phone call for this show, number 1's coming right now.
Right now, I'm on long-term disability. My employer only had to hold my job for so many months. I'm not ready to come back yet, according to my doctors, but there is a time period in which LTD does run out, and I kind of wonder, do they just let you go after that, or what can I do about it?
John, we get these kinds of questions all the time. Remember, for our viewers, people who have never seen this show before, I am a lawyer and I deal with disability law, but my partner, Lior Samfiru, who does the employment show, he is an employment lawyer. And so the two areas that we focus on at the firm, at each of our offices in Ontario and in BC, focus on disability law and employment law. And as this caller just mentioned, or just asked, as you can see, those two areas of law intersect. And the answer to this person's question is this. First of all, if you are an LTD, your employer is not allowed to let you go. They're not allowed to terminate you. Now, there is the concept of frustration of contract. If you're away for a very long time, does it frustrate the employment contract? So, and that's a good question, and that is specific to each individual case. However, the general rule is this, and this is across the country. If you are let go from your job while you are on disability or while you are disabled, that is a breach of your human rights. You're entitled to potentially severance and human rights damages. And that's important because if you're an LTD, most LTD policies out there, John, contain provisions that give the insurance company a credit or an offset in the event that you're let go from your job and you get severance. So you may think that you can just hire an employment lawyer, negotiate a great severance, and keep that money in your pocket, except that when the insurance company, your disability insurer, finds out about it, they're going to say, well, we want that money, or we're not going to pay you LTD for a period of time equivalent to what you would otherwise get from LTD that's worth the severance amount that you had received. And my answer to this gentleman is, first of all, if he remains unable to work, to do any occupation, not just his own occupation, but any occupation, his LTD payments should continue for the foreseeable future. Generally, these policies end at age 65, but if he's not 65 years old, and again, he's unable to do any occupation for which he's suited for, his LTD payments should continue. And if the insurance company says that your payments will stop at some point in the near future, again, you should question them. Why is it going to stop? Why is it that you're telling me that I'm not going to get paid anymore if I cannot work? And my doctors are saying I cannot work. So we can help this gentleman with that. We'll need to get some more information and then advise him on that piece. However, his concern obviously has to do also with his employment. And again, we can advise him on that. And it's important to understand that if you've been away from work for a few months, that's not enough to frustrate a contract. Your employer is not allowed to let you go, and if they let you go, again, you should be contacting us immediately, and we can help you with that part of the equation here, and we can do it in a way that's going to minimize what amount of money the insurance company is going to try and get their hands on. So you have to understand that the two areas of employment law and disability law intersect, and we can help you with both, and you do need to speak with a lawyer that has an understanding of both areas of law. Otherwise, you're going to miss out, and you're going to pay either the insurance company or you're not going to get the severance that you're owed from your employer.
Yeah, that term frustration of contract, that's got a pretty high threshold before you can pull that, right?
It does. It has a very high threshold, and that's what we tell people. Again, if somebody says to you, frustration of contract, we don't have to pay you anything, that's nonsense. You should be contacting us, and we'll tell you very quickly, just by speaking with you on the phone and understanding more about your facts scenario, if in fact there is a frustration of contract. But it doesn't matter, John, because in a case like this with this gentleman, clearly he's dealing not just with an employment issue, but an LTD issue. Right. So it's a good thing that he reached out, and we can now advise him on both areas of law so that he's informed and he understands what his rights are.
Let's take a short break. First one of the show coming up here. 3 reasons why you need to call a disability lawyer before going for an independent assessment. That is on the way. To reach out by phone, 1-855-821-5900. And we'll get your emails in the bit as well. That is help@disabilityrights.ca. It's a disability law show. Don't go anywhere.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason. but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And just like that, we are back. Disability Law Show. John Scholes, Sivan Tumarkin. As mentioned, we're going to get to this one. Do you want to reach out, by the way, anytime? 1-855-821-5900. Help at disabilityrights.ca. But 3 reasons why you need to go see a disability lawyer before going to an independent assessment. Sivan, number 1 is this. They will explain what to expect at this assessment, because it's always good to be out of the dark.
Yeah, it is. Light is good.
Yeah.
And again, as we said at the outset of the show, John, these assessments are nothing but independent, even though they're called independent medical assessments. The insurance companies are arranging for them, and they are paying for them. And they're doing that hoping they're going to get an opinion that gives them what they want to deny your claim or cut you off or do whatever they need to do to get rid of paying you, to get rid of you as a claimant. And so when they tell you that they want you to be seen by one of their assessors, that could be a doctor that they want you to see, a vocational assessor, it can be any number of types of assessments that they can send you to, you need to know what to expect. And depending on the type of assessment you are being sent to, and depending on your case, you need to be, you need to be prepared. You need to understand what to expect. And it's one thing to say that you should expect an assessment with somebody who is, there to give the insurance company what they want, but that's not really going to help you. You need to understand how these assessments take place, what is the procedure, what usually happens at those assessments, what happens before then. We started the show by talking about how the insurance company wanted to have an individual that contacted me sign a waiver with respect to COVID when they attend the assessment. So it's really important to understand what to expect with these assessments, what to expect before, during, and after, because again, that's going to shed some light on some things that you otherwise were not expecting.
Okay, along the same lines of what to expect at the assessment, you mentioned a vocational expert, possibly a doctor. You've also thrown around the term medical consultant. What exactly is a medical consultant?
That's a good question, John. When somebody says medical consultant, when an insurance company says that, to me that means a non-MD, somebody who's not a doctor. Now, it doesn't mean that if you don't have an MD behind your name, after your name, that you're not qualified. That's not true. For example, psychologists. Psychologists generally are PhD designation. That's what they have. And they're very, very good. They're very professional. They know exactly what they're doing. Many of my clients see psychologists, and we use psychologists as experts when we need to, deal with insurance companies. But it's very important to understand that, when you're going to see an assessor, you need to understand who that assessor is. You need to understand, where they're coming from. Perhaps get their CV, perhaps look them up, Google them. You'll get some comments, especially with doctors, by the way. But yeah, medical consultants are not generally doctors, they're not MDs, and that is relevant if, for example, you have a medical condition and you do have doctors that are treating you and are saying that because of the medical condition, you are unable to work. To me, it would be concerning if you're being sent to an assessment to check your medical condition by a medical consultant, i.e. someone who's not a doctor. So again, you want to make sure that you do your homework, you ask the adjuster who this medical consultant or the assessor is, perhaps ask them about their history with them, have they used them before, things like that. You want to understand who it is that's going to be assessing you so that you're better prepared, and that's important here. Preparation is important when you go to one of these assessments.
Okay, first step is knowing what to expect. Number 2 of the 3 reasons why you need to call a disability lawyer before that assessment is how to prepare for it. What do you do there?
Preparation is key, and we just touched on a few things in terms of preparation. I would tell you this, John. Not only do your homework on who this assessor is, but prepare the groundwork in the event that the assessment produces a report that contradicts what your doctors are saying. So, here are a couple of tips, for example. Number 1, when your adjuster says to you, I want you to go see this and this person for an assessment, confirm with the adjuster that they'll give you a copy of the report that is generated by the assessment, because sometimes they don't. And you want to get a copy of that for a very good reason, and the reason is that you want to speak with your doctors and tell them that your insurance company is sending you to an assessment, and that once you get the report, you would like your doctors to have a look at that report. Right? And that's important because imagine if, for example, you're being treated by a psychiatrist or a chronic pain doctor or orthopedic surgeon, and imagine that those doctors, any one of them that's treating you, is saying you cannot work because of an illness or an injury. And now the insurance company has sent you to one of their doctors, and their doctors disagree with your treating doctor. Well, guess what? If the adjuster is sending you the report from the assessor, you can give that report to your own doctor and have your doctor actually go through that report and tear it apart, right? Explain why it is that the assessor's report is not correct, especially given the fact that your doctors are treating you. They know you. This assessor may have seen you once for a very short period of time. So that's how you prepare. You prepare your doctors for the fact that you may give them the report. You prepare the adjuster by making sure the adjuster understands that you're going to want a copy of the report and obligate the adjuster to give you a copy of that. And you want to make sure, this is really, really key, you want to make sure that you prepare yourself for the actual assessment itself. Understand that it's not going to necessarily be an objective assessment. Understand that there's going to be some tension potentially between you and the assessor because this assessor is hired by the insurance company. And you want to make sure that if you can, take notes during the assessment. That's absolutely crucial and key because down the road when you get a copy of the report and you go through the report, you may find that many things that are in the report are not accurate in terms of the facts about your medical history, the facts about things that you've told the assessor, etc. So this is all part of preparation. And when you contact us before going to an assessment, we can give you a lot more tips and help you through the process to make sure you're comfortable with it.
So as a claimant, you ask for that assessment. Can they refuse to give it to you until someone like you, your lawyer, steps in, then they have to give it to them? Can they do that?
They can, and I've seen it happen before, which is why I tell people, when you're told go to an assessment, ask the adjuster in writing. Say, I confirm I'm going to go, but please confirm you're going to give me a copy of the report. Now, the adjuster doesn't necessarily have to give you a copy, but you've put that in writing, so it looks bad on them down the road if they don't give you a copy and decide to cut off your benefits or deny your claim as a result. Again, you are putting in, you're taking certain steps that are going to help you down the road or help us help you if you actually need our help. If the adjuster comes back and says, you should be able to go back to work, and your doctors are saying, no, you're not ready to go back to work, you want to know how to deal with the insurance company. Again, it's important to tell the adjuster ahead of time, you want a copy of any report that they end up generating, these assessors. And yes, John, they can avoid giving you the report. If we get into the picture and we start a legal claim, they can no longer hide behind their policies and procedures. They have to provide those reports. Once we actually get in there and start the legal process, they have to give us not only the report, they have to give us their entire file. Right. So that's really important to understand. They can't hide that.
Okay, third reason why you should hire a disability lawyer like you, Sivan, before that assessment is this. They're going to tell you what to do after the assessment. That's key as well, right?
Yeah, absolutely, John. We're going to tell you what to do after. And again, I touched on that already, right? One of the things to do if the report is unfavorable to you, i.e. it contradicts what your own doctors are saying, is you go through it with a fine-tooth comb, you pick out all the inaccuracies, and trust me, there are going to be a ton of inaccuracies, and you give it to your doctors for a rebuttal. That's very, very important. Now, there's a few other things that we can do with this report afterwards, and we can talk about that because it's specific to a particular assessment, whether it's a vocational assessment or a psychiatric assessment. There are different techniques and different tips and different things that we can tell you that you can do and that we can help you do after an assessment if the assessment produces a report that is not good for you. In other words, a report that allows the insurance company to then either cut off your benefits or try and force you back to work. It's very important to understand that you are not helpless if the assessment comes back and it's not good news. You're not helpless at all, and we can help you deal with it.
Totally. Reach out. Here, look what's coming up next after we take a short break. What do you do if you've been denied mental health benefits because of COVID-19? We will tackle that after that break. 1-855-821-5900. Email help@disabilityrights.ca as well. Stick around. Coming right back.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Okay, welcome back. Thanks for sticking around. Disability Law Show. Want to get to an email, by the way, anytime, even when the show's not on. help@disabilityrights.ca is the way you reach out to Sivan or a member of his team. First one comes from Liam. Liam writes, my sister has been battling COVID-19. She has a history of depression, and this infection has only made things worse. Her psychiatrist put her on some new medications after she expressed suicidal thoughts. She was denied long-term disability because the insurance company found Facebook photos of her smiling and going for walks. Is that enough for them to deny her claim?
No, it's not. That's the short answer, John. It's not, Liam. And I'll tell you this, we've spoken about this before quite a few times about social media. Look, insurance companies will use whatever they can to cherry pick photos, to cherry pick, information from doctors' reports, to do whatever they can to cut you off or to at least support their position as to why it is that they're not going to pay you. This is important because, you think that you're putting something that's innocuous, something that is not a big deal on your social media, whether it's Facebook, Instagram, TikTok, whatever it is. And the reality is that the insurance company will, if they can, weaponize it. They will weaponize it against you. And they understand that they can gaslight individuals out there, John, especially people who have mental illnesses. The reality is this, they're not doing this because they're bad people, these adjusters. I mean, it's just like anyone else, right? Any other industry, you have good people and bad people, but generally speaking, they think they're doing their jobs. And what are their jobs? Their jobs are to save the insurance company money. Remember, the insurance company is in the business of making money. They do that by collecting premiums and paying as little as possible, if anything at all. So I'm not surprised when Liam writes to us about a very, very difficult situation his sister is in. And, just because of a few photos on Facebook, the insurance company has declined her claim. Look, we can help here. We can help with claims like this, and we have helped with claims like this, especially a situation like this where it is so obvious in terms of what the insurance company is doing here. The concern I have is, people out there who don't have someone like Liam who's going to contact us. Someone who is going to get this email or letter from the insurance company saying, oh, we saw a photo on your website on Facebook or Instagram or whatnot, showing that you're taking a walk in the park or that, you look happy. You're in some kind of a celebration or something. And so therefore, that's proof that you are not disabled from working. That is ludicrous. It's nonsense. The insurance companies know it's nonsense. But you have to challenge them. And you don't have to do it on your own. And that's the key here. We are going to help Liam's sister. We help tons and tons of people all over the place with these kinds of situations, John. And what I would tell people is, if you can, avoid putting these kinds of posts on your social media. Okay? We had one time on our show a private investigator who suggested that people who have injury claims and disability claims go dark, quote unquote, right? And what he means by that is simply don't post anything while you have a claim ongoing. Not because you're lying, but because you don't want the insurance company, again, to weaponize it against you, because they'll do that. Remember, they are there to do whatever they can to use whatever is at their disposal to cut you off or deny you benefits. Don't give them the ammunition. But if you do, and some people do, people need to be social, especially now with COVID. People feel very isolated, right? It's exacerbated the situation. If you're in that situation, like Liam's sister, please reach out to us. We will be able to help you.
Plus, this is a mental health claim. We're not talking a busted hip or somebody in traction. Maybe, just maybe, their psychiatrist said, hey, it might help your situation to get out and be social.
100%.
Go for a walk. Come on.
Sure. You see that a lot. I see, people contacting me saying the insurance company had done surveillance and they showed me going into a gym, and exercising or swimming twice a week. And they say, well, that means you're not disabled. And people write to me that they have depression, anxiety, really disabling conditions. And in fact, their own doctors have suggested that they go to the gym or go and swim and do, physical activity. But the insurance company doesn't see it that way. Here's the thing. I don't care how insurance companies interpret this information. What I care about is you not giving up on your rights. That's the key thing here. If your doctor is okay with you doing a certain activity, or in fact recommended it, and then the insurance company turns around because they have some surveillance or they got something from your Facebook and they say, because of that, we're going to cut you off or deny your benefits. No, that can't fly. And we can help you go after the money that is owed to you. That's really what it comes down to, John. I often give the example of somebody who's 30 years old who was cut off or denied disability and they're supposed to get $2,000 a month. An example. That's $24,000 a year. If that person is disabled even for just 10 years, that's $250,000 that the person can be walking away from if they simply take whatever the insurance company is telling them at face value and walk away from their claim. Do not walk away from your claim until you get proper legal advice, until you are informed about your rights, about your specific situation. And this is what we do each and every day for free with people. Okay? It doesn't cost anything to get this information and to talk to us.
Couple minutes to go, pal. Let me slide in one more email. This one's from Eva. Quickly says, my 41-year-old husband was recently cut off LTD because the insurance company said that he reached the 2-year mark of his claim. He has severe migraines and chronic knee pains after working as an airport luggage handler for the past 15 years. His doctor offered to speak with the adjuster, but the adjuster refused to and told my husband to appeal the denial. Will that appeal work? I know your answer on this one. Well,
John, we need a whole show just for this question here. But first of all, do not appeal these denials. Okay, these appeals are internal processes for the insurance company, and once you appeal these, they'll just have you looped in. You'll appeal again and get denied, appeal and get denied. So don't appeal these things. Now, in terms of what Eva writes here, in terms of her husband, look. The reason why he's being cut off at the 2-year mark, which happens quite often, is because the test for disability, the criteria you need to meet to get LTD beyond 2 years changes. It doesn't mean that he's not eligible for LTD. In fact, if his doctors say that he cannot do any occupation for which he's suited for, he should continue to get LTD. He should not be cut off. But again, many people think that their LTD payments ought to end or just automatically end and expire after 2 years. No, that's not the case unless the policy is a 2-year policy. I have rarely seen policies that are 2-year policies. Usually they take you to age 65. Yeah. So it's a good thing Eva contacted us because there's a lot of things to unpack here. We're going to be able to help her husband. In fact, I'm almost positive that once we get in there and deal with the insurance company directly, they're going to come to the table fairly quickly, knock on the door and say, can we settle this case? And that's the best case scenario for Eva's husband.
Yeah, it's interesting, that appeal process. People think it goes to some, provincial tribunal or someplace outside the law firm. It's not. As you said, it's internal. It's still within the walls of the insurance company.
It is. And John, listen, I still get people contacting me saying, you know what, I listened to you over and over, but I still decided to appeal it myself. This was 5 months ago, 6 months ago, a year ago. And again, I just got a denial and another denial, another denial. And you know what I tell them, John? I said, it's too bad you didn't listen to me in the first place. But we'll be able to help you now. It's just that you've wasted a year's worth of time. We could have resolved your case by now, most likely. So, people need to understand that when I say that these appeals are useless, it's because I speak to people all the time, and that's information that I get from them. I've been in this business long enough to tell you that the insurance company wants you to appeal because it's good for them, not because it's good for you.
And you got to watch that 2-year limitation. I mean, that time's ticking, right?
If you do not start your legal claim within 2 years of the date of first denial, you are jeopardizing your legal claim. You understand that? You could be in a position where the insurance company is laughing all the way to the bank, because if you start a legal claim after 2 years, they may be able to bring an application or a motion to a judge to knock off your claim. So you do not want to do that. That's why I tell people, John, make sure you contact me as soon as you are told that your benefits are going to stop or as soon as you are denied, immediately.
Good stuff for another day, pal. Packed a lot in there. You'll want to reach out to Sivan and his crew. It's really simple. The phone, 1-855-821-5900. The email we use every show is help@disabilityrights.ca. You want to shorten that just to disabilityrights.ca. That would be the website. Thanks for tuning in. We'll catch you next time on the Disability Law Show.